Hello and welcome to the Citizens Law School from the State Bar. My name is Anna Conley and I chair the Law Related Education Committee for the State Bar, and I'm a law professor at the University of Montana Law School. Today we are going to have Shane Morigeau talk about tribal laws in the state of Montana. I'm sorry, Shane. Shane was born and raised in Ronan and he lives here in Missoula. He is a proud Salish and Kootenai member, and he grew up fishing, biking, hiking, and hunting right here in Montana. Before earning his law degree in LLM, he spent his summers fighting fires. He had his pilot license, and he has a bachelor's of science in resource conservation from UM. He began his law career as an advocate and attorney for the Confederated Salish and Kootenai tribes, and he helped pass the CSKT Montana Water Compact and Medicaid expansion in 2015. Prior to joining CSKT, he was the deputy executive director in December of 2021, and he served as a prosecuting attorney and general counsel for the tribe for over a decade. He was elected as a state representative and minority whip in 2016. He just got elected to the Senate, and so we're thrilled to have him. He's passed a lot of great legislation, including some strong legislation protecting child abuse victims and students abused in our schools. So I want to welcome him, and I want to just also mention that the purpose of Citizens Law School is to try to engage the public, give the public a sense of what lawyers and judges do every day, make sure that the courts are accessible, and that we are fostering a sense of the importance of having our courts and our legal system to peacefully resolve disputes in Montana. So with that, I'll turn it over to you.
All right. Well, thank you, Anna, and thank you to everyone who jumped on tonight. I think I ended up going to bed at 3 o'clock last night waiting for election results to come in. So, didn't really think about that before volunteering for this particular date, but I'm still very excited to be here with all of you. And Anna, don't worry about calling me Sean. My brother's name's Sean, and my mom called me Sean for probably half of my life. So no big deal. But I do want to get started and start sharing my screen here, the PowerPoint that I have here. So bear with me. All right. Can everyone see that okay?
Yeah, it looks great.
Okay. All right. Well, today I'm going to talk to you a little bit about tribal sovereignty and the state intersection. I'm not going to get into a lot of detail. I might skim over a few things, but for me, this is a really great place to start when we're talking about tribal laws and who Indians are in Montana and what that structure looks like. I really like to go into detail and talk about the policy eras, because I think the policy eras are a really great way of understanding Indian law, because it can be very complex and complicated. You're not going to learn everything about Indian law today, but this will at least give you an idea of how those policy eras help structure and shape Indian law in Montana and throughout the country. So who the heck am I? I think Anna already did my introduction, but my grandpa on my dad's side was Chief Charlo. Very proud of that on my dad's side of the family. My mom's family is Dishaws, McClures, and so, McDonald's, related to the McDonald's on her side as well, and Swaney's. So big family, practically on the reservation. Feels like I'm related to everybody as a Morigeau sometimes. I was barred in 2011, and I currently serve as a deputy executive officer for the CSKT. And when I'm doing that work, I actually focus on communications and public affairs work. So before we get started, just to really quickly, I'm going to clear all of these. I want to just say, our Aboriginal homelands of the CSKT, our territory actually stretched all of Western Montana to parts of Idaho, British Columbia, and Wyoming. Our territory actually spanned over 20 million acres before we entered into the Treaty of Hellgate. So I just kind of want you to think about that, because when we entered into our treaty, we gave up a lot. in that contract, that contractual document that we entered into. So sovereignty, when I ask people what is sovereignty, I actually like to share this video, actually not to make fun of this particular person, but because sovereignty can be confusing, and there is a lot of confusion around what that means for tribes. So I'm going to share a quick video with you all.
My name is Mark Trahan. I'm the editorial page editor of the Seattle Post-Intelligencer and a member of the Native American Journalists Association. Most school kids learn about government in the context of city, county, state, and federal. And of course, tribal governments are not part of that at all. Mr. President, you've been a governor and a president, so you have a unique experience looking at it from two directions. What do you think tribal sovereignty means in the 21st century? And how do we resolve conflicts between tribes and the federal and state government?
Are you guys all able to see this right now?
We can hear it, but we can't see it.
Oh, weird. Okay. My screen is saying screen sharing is paused. So let me, for some reason, it pulled me out of screen share. So maybe I have to go back to that. All right, let's try this one more time.
Of the Seattle Post-Intelligencer and a member of the Native American Journalists Association. Most school kids learn about government in the context of city, county, state, and federal. And of course, tribal governments are not part of that at all. Mr. President, you've been a governor and a president, so you have a unique experience looking at it from two directions. What do you think tribal sovereignty means in the 21st century? And how do we resolve conflicts between tribes and the federal and state governments?
Tribal sovereignty means that it's sovereign. You've been given sovereignty and you're viewed as a sovereign entity. And therefore, the relationship between the federal government and tribes is one between sovereign entity.
All right, so I like to share that particular video because, you know, it is when someone asks you that particular question, your mind probably is like, well, what does that mean for tribes? And, you know, typically you just kind of think like sovereignty is sovereignty, right? You're there, you have the inherent right and power to govern yourself, right? And that can be a loaded question and often confusing because I think sometimes people don't understand what that means for tribes. And, you know, even our president at one point, you know, who actually had pretty good relationships with tribes throughout his tenure, you know, didn't really understand or grasp that history because it can be complicated at times. So, so tribal sovereignty, it refers to the right of American Indians, Alaska Natives to govern themselves. The U.S. Constitution recognizes Indian tribes as distinct governments, with a few exceptions, the same powers as federal and state governments to regulate their internal affairs. And sovereignty for tribes also includes the right to establish our own form of government, determine our membership, enact legislation, and establish law enforcement in our court systems.
And Shane, I'm sorry to interrupt you, but your slides aren't progressing on my screen, just FYI.
What is it on right now?
It's on slide, it's on the opening slide, tribal sovereignty and state intersection.
Weird. Okay. Is it not moving still?
It's not moving for me, but I think I'm tracking what you're saying and it's going great. I just wanted to let you know. I'm not sure if other people are having that issue.
Is it working now?
I'm not seeing your slides progress on my end.
Still nothing?
No,
Hmm. Well, let me just close out of it and then I'll try and reopen it.
and like I said, I'm tracking what you're saying great, so might not need it. Just wanted to give you a heads up.
Yeah, no, I would like folks to be able to see the PowerPoint because they're progressing on my screen.
There you go.
All right, it must have just been a glitch in the screen sharing or something, because all I did is close it and reopen it. So, all right, well, that's technology for us. So what does sovereignty mean? Inherent right and power to govern oneself. The Constitution in the US gives authority to Indian affairs to the federal government, not to state governments. Just as the US deals with states as governments, it also deals with tribes. Tribes aren't special interest groups or non-governmental entities. And some states have actually recognized the status of Indian tribes. Montana's constitution actually represents or recognizes Montana tribes in the state constitution as well. So to the policy eras and why we are where we are today. So I like to start with this and talk about the policy eras because I think it really gives you an idea of what tribes are and how we've been structured through time. So the federal role from colonial times to 1820, tribes conducted our own affairs. We didn't have any outside influence or power to there to legitimatize us in our acts and our governments. Tribes were treated as sovereign nations with the British Crown, the colonial powers, and we were left to regulate our own affairs. And when colonies revolted, a lot of tribes actually allied with the Crown because the Crown protected tribes and recognized tribes as sovereign foreign nations. And so things changed after the Declaration of Independence in 1776. Upon independence, Congress actually incorporated into the Constitution that they regulate commerce with tribes, and the president was empowered to enter into treaties with tribes with consent of the Senate. We also had the Trade and Intercourse Acts passed, which separated Indian and non-Indians, and interactions between them were to be through federal control. Boundaries were established, and non-Indians couldn't acquire land from Indians, and that was for multiple reasons. The federal government wanted to have control over that, but also we didn't want people to take advantage of tribes, and tribes didn't really view lands in the concept of fee simple property, right? We were nomadic. A lot of us, like I mentioned when we first started CSKT, our territory was 20 million acres, so we moved around in those areas as the tribe's territory. Indian tribes were left to really regulate our own conduct at that time. And on one hand, you had Europeans claiming dominion over all territories of the New World, which would end up really limiting and restricting and clouding tribal sovereignty and the status of tribal sovereignty for tribal nations. And a lot of that was left to the US Supreme Court, as I'll talk about here in a second. So we started with the Cherokee cases, which were these like landmark cases in the era called the Cherokee cases and Indian removal era, which ran from 1820 to 1850. And at this time, we had extinguishment of Indian title to Eastern lands and removal of Indians beyond state boundaries. So Indians were being pushed westward because as we had Europeans coming into the country and settlers, Indians were being pushed west. We had President Monroe and John Quincy Adams, and most vigorously Andrew Jackson, who really implemented what we know as the Trail of Tears, where we had the removal of 60,000 Cherokees from that were removed from their territory to Oklahoma. Friction was primarily over land and resources. And to give you an idea of how tribes were viewed at the time, the Bureau of Indian Affairs, which is now under the Department of Interior, was actually under the War Department from 1824 to 1849, which that gave you, like I said, it gives you a sense of how the U.S. felt about Indian tribes at the time. Simultaneously, we had the U.S. Supreme Court developing legal doctrines that would structure Indian law for up until now. We still use those landmark cases. And so that really started the structure and future of tribal sovereignty. So the first big case that you might hear people talk about often is this case called Johnson v. McIntosh, which was in the court ruled on in 1823, where they said Indian tribes can only grant lands to the federal government, exclusive title to those who discovered it under the doctrine of discovery, which was a Christian concept of Christian nation actually is the owner of the land because they discovered it, not the tribes, because tribes were considered heathens. So tribes had the right to occupy, but didn't have the right to dispose of the soil. The soil couldn't be diminished. The next case that came about, which was a case that shaped Indian law till this day, is Cherokee v. Georgia, where the Cherokees were not regarded as a foreign state under the Constitution, but they qualified as a state. And that's much different than what I mentioned earlier with the British Crown, because under with the British Crown, they recognize tribes as sovereign nations, foreign nations. That changes with this case where the court now says, actually, we're going to treat you more like states and not foreign nations. We were distinguished as political societies separate from others and managing our own affairs and to governing ourselves. And at this time, this phrase was coined under this case as tribes being domestic dependent nations. The last landmark case that I think is worth mentioning is Wooster v. Georgia. And in this case, the Supreme Court stated that Indian nations had always been considered distinct, independent political communities, retaining their original natural rights and the undisputed possession of the soil from time immemorial, with the single exception of that was imposed by irresistible power, which excluded them from intercourse with any European country, essentially the first discoverer of the coast of particular region claimed, which means that we could only really deal with the United States. We couldn't go and dispose of lands to another country. It determined at that time that the laws of Georgia actually had no force and effect in Cherokee territory. So the laws of another state didn't have any effect in that Indian territory. And it was a limitation to sovereignty, the conveyance of land in dealing with foreign powers. And at this time, this is where we had like the Trail of Tears era happening simultaneously. Andrew Jackson actually was really at odds with the Supreme Court, where he said, you know, John Marshall made his decisions, now let him enforce it. And this was in response to the Indian Removal Act at the time in the 1830s, where the Congress or the president was really trying to force Indians out of territories to get lands for settlers. But this case was actually a case that protected tribes from states, incursions by states. And this was really Andrew Jackson's response to him. And shortly after, we saw the Trail of Tears occur, where 60,000 people were forced out. And I think thousands died in that particular, in the Trail of Tears. So the next era that we go to is the reservation era, which was from 1850 to 1887. And again, this was another attempt to assimilate and take lands from tribal people. So for CSKT, we entered into what was called the Hellgate Treaty, and that established the Flathead Indian Reservation of 1.317 million acres. And again, over 20 million acres of Aboriginal territory is what we considered our territory at the time. And that was ratified by Congress in 1859. Interesting fact about this particular treaty is that There was also a second reservation that was supposed to be formed under the Hellgate Treaty, which was supposed to be in the Bitterroot Valley, and was supposed to be surveyed and examined. And there was the president was supposed to determine whether or not that was more suitable for the Bitterroot Salish as a separate Indian reservation, but instead said, we actually believe the Flathead Indian Reservation is more suitable for the Bitterroot Salish. So we were eventually forced by gunpoint out of the Bitterroot Valley to the Flathead Indian Reservation. And what I've been told is that an actual survey was possibly never done, and that the survey consisted of someone getting on a horse and riding the area to just basically come up with a reason to say a survey was done. Simultaneously, I have a comment in there from Chief Charlo, because the Bitterroot Valley was home for the Bitterroot Salish. Chief Charlo was said to have said that that's where the bones of our ancestors are, and that's why he didn't want to leave the Bitterroot Valley. Simultaneously, we had the Homestead Act of 1862 being enacted in Montana, which was competing interests for land and territory. And then we had treaty making era ended in 1871. Right around that time in 1878, we saw off-reservation boarding schools, which is, we're still feeling the effects of that today. And after 1871, treaties were entered into via statute or by executive order. Congress ended the treaty making era in 1919. So allotment and assimilation. This is another era that I think is important to understand. In 1887, the General Allotment Act was passed, and tribal members would get land. The intent was to give tribal members land so that they could prosper and assimilate as middle-class agrarian farmers. But really what happened was, and what was intended was to break up the land bases for farmers so that excess lands or surplus lands, as they called it, could be sold off to homesteaders. So at the time, 160 acres went to each head of family and 80 acres to others. They doubled that number if the land was only suitable for grazing, which a lot of the territory on the Flathead Indian Reservation is only suitable for grazing. 138 million acres in 1887 for tribal lands was diminished to 48 million acres by 1934 because of the allotment era. On October 14th, 1891, the Bitterroot Salish were pushed out at gunpoint from the Bitterroot, which is, there's some where the Higgins Bridge was formerly the Higgins Bridge, but now Bear Tracks Bridge, which is an area where the Salish crossed to make their way over to the Bitterroot Salish crossed to make our way to the Flathead Indian Reservation, which was considered our Trail of Tears. So we entered into the treaty in 1855. The Bitterroot Salish stayed in the Bitterroot until 1891, assuming that they were going to be able to stay, which was not the case. Around this time, tribal powers were determined to be inherent, not derived from federal government. So that means basically tribes have inherent sovereignty, inherent powers of government, and that the government doesn't go in and say, here are your specific powers. They're actually inherently held by the tribes. Around this time, a famous case called Talton v. Mays was issued by the Supreme Court, which said the Bill of Rights that restricts the federal government do not apply to tribes. In 1904, the Allotment Act was extended to CSKT, and our land base went from actually 100% of the whole entire reservation, the 1.317 million acres, to under 30%. So we went from owning the entire land base on the reservation to roughly 30%. And now that's back up after the tribes have underwent buybacks for years and years to now up to around 67, 68%. From 1908 to 1909, the bison range was carved out, and 3,000 lotteries were issued for homesteading, and another 3,000 in 1910. The remaining public lands were open for public sale, and so the total loss of acres on the Flathead Indian Reservation was 400,000 acres, and a total of 90 million for tribes across the country. The 1920s also had another round of tribal allotments with updated rules with timber allotments that were 168 acres. The federal government also came in and established villa sites, where they gave 5 and 10 acre parcels along Flathead Lake and divvied those out. We're the only reservation in Montana that didn't undergo the allotment act was the Rocky Boy Indian Reservation, which was formed in 1916. But their reservation is very small and actually was probably a product of what was happening with allotments in the first place. Their land base was very much diminished, and that is a very small reservation. So in a way, they, in my opinion, the Rocky Boy Indian Reservation, although not specifically allotted, experienced their own excessive diminishment of their land base. In 1924, around this time, tribes got citizenship. So in 1924, Indians became citizens if you were born in the US. You also became a state citizen if you were born in the US. So here's a few maps. I like to share these maps because they're pretty good at showing what the tribe's land base started at and what happened after the allotment and homesteading happened and the surplus lands were sold off. So the first map is all green, it's all tribal lands. The second map is when they came in and said, we're doing allotments, we're going to sell, we're going to give chunks of land to tribal members. So that's what the orange is. So that's what it looked like after the reservation was allotted and chunks of land were divvied out to tribal members and families. And then the last map is what it looked like after homesteads were issued. And you can see the significant diminishment. Also, you can see state school sections throughout that are in gray. The federal government issued state school sections 16 and 36, and every town site was issued to the state. So that's what all those gray boxes are, and that's that last map there as well. So, so 400,000 acres from that first image to that last image is what the tribes lost during that time frame in that era. And that big purple spot was the national bison range that was carved out. That's now actually green on the map because that was restored to the tribes. So Indian reorganization and preservation era that occurred between 1934 and 1953. So at this time, the Indian Reorganization Act of 1934, also known as the Wheeler-Howard Act, was issued by Congress, and that was to protect the land base and set up legal structures for tribal governments. So this is where they finally said, look, let's stop allotting out tribal lands, and tribes can form constitutions and bylaws that have to be approved by the Secretary of Interior for government. So CSKT was actually the first to submit a written constitution that was approved by the Secretary of Interior. From 1953 to 68, we had the termination and relocation era. And that's where Congress enacted laws to terminate government's trusteeship of Indian lands and relocate Indians to cities. And actually, a family member of mine, one of my uncles, actually was a product of that. He was relocated to a job somewhere else. Again, in essence, this was an attempt to say, let's get Indians into jobs, recognizing that a lot of those policies we just talked about were failing. This was now an attempt to try and say, let's try and find ways to get Indians from these communities into employment positions, but actually had a negative net effect because it actually removed people from their communities and took them away from their culture, their language, which also still has a ripple effect to this day as well. Lands were, during this time, tribes plunged into deep economic troubles during the termination and relocation era. Again, the termination legislation that was passed was basically to say, hey, let's make Indians just state citizens and only subject to state law, and convert lands into private ownership. We also saw Public Law 280 in 1953, which diminished the role of tribes and subjected 5 mandatory states to state criminal and civil laws throughout the country. Right around this time, we also saw the Voting Rights Act of 1965 put into place because we had recognized in this country that there was a lot of voter suppression happening even after citizenship was gained in the 20s, that people were being disenfranchised from being able to vote. So this was enacted, and still after this was enacted, we continue to see voter suppression efforts. So this is the self-determination era from 1968 to now. The Civil Rights Act of 1968 was put into place to impose the Bill of Rights, and Public Law 280 at around this time that I just mentioned. Tribes actually had to consent to criminal and civil jurisdiction now. The termination policies were actually declared a failure by President Nixon, and he came up with a new law called the Indian Self-Determination and Education Assistance Act, which allowed tribes to contract programs and compact programs. And so I have this highlighted in green just because, and actually for some reason this is now showing a version I saved prior to updating this, but to give you context of like why these programs were on the reservations for like tribal health or forestry programs or lands programs is because we entered into these treaties that were these contractual obligations where tribes gave up lands in exchange for these sorts of services to be provided in perpetuity. And so a lot of these programs were created on reservations, and over time they actually became a place for government, for the US government and employees actually would come in and sadly use it as an opportunity to line their own pockets. So Indian agents that had came out to work in these areas would actually use these as an effort to make money for themselves. And that was evidenced in a case called the Cobell case, which the US government was sued for mismanaging funds for tribes. It was a class action lawsuit. Around this time, I'll skip over these three items, but around this time we also had in 1994 we had a case, or not a case, but President Clinton issued an executive order basically saying that government to government relationships with tribes have to happen, and he instructed each agency to have those relationships with tribes, to start consulting with tribes. The Congress, and during this time, we also saw some more cases that identified what Congress's power is with tribes. So, I mentioned earlier that tribes have inherent sovereignty, but the federal government can restrict that, which Congress has done. So like an example of that is Public Law 280, where Congress restricted criminal and civil jurisdiction in Indian country. And there's many more examples of how tribal sovereignty has been restricted over time, but that's a good, gives you a good idea of what Congress's plenary power is. They can implement laws that can restrict the tribe's ability to govern themselves. All right, so compacting and contracting today. So in my opinion, this is a really important, for tribes moving on into the future for tribal sovereignty, because those programs that we just talked about, I think it's important for tribes to have control over those programs to make decisions for our membership. So self-governance, again, is it's a means where tribes can come in and run a program that was initially ran by the federal government, and the tribes will step into the shoes and run that program. There's also contracting of those programs, 638 contracts. Tribes can utilize that as a means to run those programs as well. There's some examples of that where programs are compacted at CSKT or Indian Health Services, tribal lands, programs that are contracted under a contract with the federal government is our forestry program, Mission Valley Power, and Two Eagle River School. So this is kind of where I think to kind of pull those policy areas into place here and talk about like state intersection. You know, CSKT went through, you know, those policy areas of allotment and assimilation. And, you know, now today, although our land bases are around, you know, I mentioned 67, 68%, the population on the Flathead Indian Reservation is 80% of the population is non-Indian. And we continue to have a checkerboarded reservation with mixed populations and mixed jurisdictions. So we have, you know, county, we have cities, we have the tribe, we have state, and we have federal government. And so trying to manage that mishmash of jurisdictions can be a lot of work, and there can be differences in how that jurisdiction looks between those entities. So also tribal people are tribal citizens, US citizens, and state citizens. As I mentioned earlier, it wasn't until 1924 that tribes or Indian people were granted US citizenship. Before then, some treaties or allotment acts extended citizenship to individual Indians. But since 1924, anyone born in the US or born to citizens, parents outside of the country are US citizens with all the attendant rights and responsibilities. So this is something that I often have to educate folks, especially when I'm in Helena, talking to them that, you know, Indians are state citizens. And that's why when it's important to have that representation in the state legislature, because the laws that the state of Montana passes, the elections that we have impact Indians as state citizens. US citizenship is not inconsistent with tribal membership, and it does not affect the special relationship that exists between Indian tribes and the federal government. So other things that can kind of make things complicated with those different jurisdictions is obviously we have different constitutions. We had statehood, and we have the federal constitution, we have tribal constitutions. And so when we talk about complex issues, taxation is one of those that comes up often. Tribes are actually limited in their taxing authority, and that's through a lot of various case law. Also, when tribal communities sit at the bottom of every social indicator, so typically we have low income communities, doesn't make a lot of sense to tax low income people. So tribes are really left to diversifying their portfolios and trying to find business efforts to build their general funds and coffers to provide services for their membership. Montana has revenue sharing agreements, which is a way for the state and the tribes to work together through these complex jurisdictional issues on taxation to come up with a way to avoid litigation and to ensure that the tribes are getting their tax revenue for members to the tribes. So the tribes and the state will often enter into these things we call revenue sharing agreements. I mentioned the education system because almost all of our Indian community, whether it's in urban areas or on reservations, go to public schools. And so funding of public schools is extremely important. It's one of the great equalizers for Native people. And so funding those adequately is very important. And that's why Indian communities often advocate for adequate education funding, because our students, our people go to those schools and depend on them to have equal opportunity. I mentioned Two Eagle River School earlier. Two Eagle River School is actually a tribally controlled grant school. So the tribe's CSKT controls that school and gets a contract, has a contract with the federal government for some funding to help support the school. But the tribes often have to supplement the school with additional funds from different places. I mentioned this already, this executive order that President Clinton issued. This this is the actual executive order number 13175, and that this executive order has been continued by presidents. Even currently was renewed by the current president. And in the past, I believe every president has entered an executive order to recognize this consultation in coordination with Indian tribes with programs and agencies within the federal government on important issues. So this kind of breaks that down, the requirement for them to consult. And lastly, I think it's good to mention the overlap on Montana policies. So, when we talk about wildlife and resources, aquatic invasive species, gaming, education, alcohol, tobacco, criminal law jurisdiction, language preservation, managing water and air, there's a lot of overlap in those resources, right? They impacts to wildlife can impact wildlife on the reservation. Water quality, one place on the reservation impacts water quality other places. Clean air impacts everybody in the community. So the tribes obviously in the state all have this interest in regulating those things. So oftentimes we're having to work together to find a way to manage those things together and balance those interests in those various jurisdictions of tribes and the state of Montana. Under federal programs, we have funding and grants that come to tribes, just like the state of Montana. We have some funds that are direct, and then we have some that are pass-through funds. So, for example, like Medicaid expansion, when that was passed in Montana, it had to be passed in Montana before tribes could actually access those funds. Early childhood services are directly funded through contracted grants. And Salish Kootenai Housing Authority is also a program we have back on the reservation, which is a program that receives direct federal funding from the United States. To kind of wrap up and share just some resources. This is just some good resources that I go to. The American Indian Law in a Nutshell is a book that I go to regularly. A lot of those policy areas that I just talked about with you are in that book. It breaks those down very nicely. So if you ever are curious about like certain subject matter issues or just those policy areas, you can go check that particular book out. And then here's some just other great resources on tribal sovereignty. The Montana budget and policy has some great resources on Montana tribes, NCAI, NARF, they all have really good resources. The National Conference of State Legislators also has some really good information on tribes and tribal sovereignty as well. So with that, I do want to leave just a little bit of time for questions on any of the topics that I just went over with you all.
Thank you. Wow, that was absolutely wonderful. I just learned so much. The folks who are listening in, feel free to drop some questions into the chat. In the meantime, do you mind if I ask a question, Shane?
Sure, go ahead.
You went through the different eras, and I'm wondering what your thought is on best case scenario for next era.
Yeah, I mean, we're still in that era that I mentioned at the end, self-determination era. And I think, the tribes having the ability to, make decisions for our own people is really important, right? And there's some current cases that, I disagree with that, that the Supreme Court has issued recently, which I think has some pretty strong implications for tribes and tribal sovereignty in the future. Those things can change. The court, here's a lot of Indian law cases. But, I think giving tribes the tools to protect our membership, the health, welfare, and security of our people, and having the jurisdictional capacity to do that shows that, the statistics show and data shows that we're more successful when we have that ability. And, for example, I didn't really talk about this during the allotment era portion of the presentation, But when the allotment era came into place, to, turn tribes into agrarian farmers, CSKT, a lot of CSKT members were actually already farming and actually had lots of horses and cattle and very successful cattle ranchers. And then after the allotment act actually happened, we actually saw a massive decrease in cattle and horses. So it actually had the opposite impact and effect than what tribes were actually doing on their own when they had the ability to manage their own affairs and to have be agrarian farmers on their own if they wanted to so chose to do that.
Oh, interesting. Yeah, feel free, anyone that has a question, to drop it in the chat. My next question is, Shane, what do you foresee as being tribal sovereignty issues or bills in the coming state legislative session that we should be thinking about and keeping our eye out for?
Yeah, that's, Montana has a constitutional commitment to protect the cultural integrity of Montana Indians, recognizing that Montana Indians are woven into the fabric of our culture and our identity here. And so, we've really tried hard to make sure that, our state is actually funding programs for language, to preserve and protect language, because that's important for Indian people. Our stories are tied to, our language, our culture is tied to our language, and our identity is. So, without that, we lose a lot. And a lot of the loss of that was, a ripple effect of some of those policies, a lot of those policies that I went through. Another thing that I would expect that, we see a lot of to this day is we see bills that inhibit the ability for tribal people across the state of Montana, Indian people, to be able to cast their ballot. So, every session we pretty much see efforts to, restrict that ability, in my opinion. And trying very hard not to make it political, but in my opinion, that's a net result, right? Is when you pass laws that make it harder for people to vote, it really impacts low-income communities, including our tribal communities in the state of Montana. So when you have bills that restrict ballot collection, or people restrict the ability for people to pick up ballots and turn them in for people, I often give the example of like an elderly person who doesn't have anyone to drive her or to care for her, to take her to go get a stamp. So oftentimes they're dependent on people helping them, especially if they have a disability. So, those are just a couple of examples of bills that, things that we think are important with the Indian caucus and in the state of Montana, and then B, the type of bill that we typically see in the state of Montana that, impacts tribes negatively.
Can you talk a little bit about the makeup of the Indian caucus geographically and from a tribal representation perspective?
Yeah, so one of the things that's really important in Montana is the redistricting of legislative districts that's coming up. And so right now, our representation in the Montana legislature is around 7%, which is actually around the population of Montana Indians in the state of Montana. So it's representative of that. We possibly have lost two. We lost one for sure. Representative in this last election cycle. We have one that's still in a pretty tight race. So that number will probably be drop a little bit. But the way the districts are set up right now, we have representation from pretty much every single tribal community in the state of Montana. So, we have someone from Northern Cheyenne, Rocky Boy, Fort Peck, Salish and Kootenai, Blackfeet, so on and so forth. We don't have one actually in the territory for Salish and Kootenai tribes, even though I'm a member of the Salish and Kootenai tribes. I actually live in Missoula. So the way that district is set up, there's no actual CSKT member in the state legislature. And again, that's part of that is because of the way these policies we just talked about have impacted the Flathead Indian Reservation, and trying to structure a district there to capture the population with the non-Indian population makes it very difficult for the redistricting commission to come up with that. So the redistricting commission is getting ready to, they've issued initial maps. They're they're still working on pretty far away from completing maps that will finish the redistricting of the new districts in Montana, but that's currently in the process, and it's still open for public comment, for people to make comments about what those districts should look like, which obviously tribes across Montana are very concerned about what those districts look like moving forward.
Oh, interesting. Shane, can you talk at all about tribal courts and the types of cases that they hear, and what that process looks like?
Yeah, so a lot of tribes are, and this is this could be its own presentation. So tribes are have their own court systems. Like CSKT has a court system that handles civil matters and criminal matters. Tribes are limited in what they can do with punishments under federal law. So tribes are restricted unless the tribal law, unless they meet certain requirements under the Tribal Law and Order Act. Tribes are restricted to certain a year in jail or a $5,000 fine. So unless you meet certain requirements under the Tribal Law and Order Act, that increases to 3 years, and I think $10,000 is what the fine is. So tribes, so a lot of tribes don't actually prosecute cases like murder, or the U.S. attorney comes in and prosecutes those sorts of cases on all the reservations in Montana, except for the Flathead Indian Reservation, which is the Public Law 280 reservation, where felony jurisdiction, the state of Montana, under that law I mentioned in the presentation, state of Montana and the tribes consented to this, entered into Public Law 280. So the state of Montana prosecutes felonies on the Flathead Indian Reservation, and then the tribes prosecute misdemeanors. And then the tribes also have, again, like our own civil, we have our own court system that does civil and criminal. So people can get married in tribal court, they can get divorced in tribal court. And then you can, they also prosecute like fish and game offenses and those sorts of things as well. So it's, and for CSKT, we have like our own criminal laws or criminal ordinance, which actually incorporates a lot of Montana traffic laws. So like certain DUI laws that are incorporated in the that are adopted in Montana are incorporated into the CSKT code. So they utilize that for prosecutions of like DUI and those sorts of things.
Great. Wow. Well, I've taken up a lot of time with my questions, and I'm not seeing any in the chat. Are you, Shane?
I don't see any in here.
Okay. Well, then with that, you have some celebrating to do, Shane. So on behalf of the State Bar Law Related Education Committee, I really want to thank you for coming today and for taking your time. This is a really informative and educational presentation. I learned a lot, and I think it's really important for Montana to appreciate that there are these tribal sovereigns, and that they are functioning legal systems and functioning sovereigns. And so I really appreciate you sharing that information with us today. And anyone who's signed on, we have 2 more weeks of Citizens Law School. We have next week, and then we're taking a break right before Thanksgiving, and then we're coming back on November 30th. So please join us. And then also you can let folks know that these will be recorded and put up onto the Montana State Bar website. So thanks again, Shane. Take care and congrats.
Thanks for having me. Have a good night.
All right, bye-bye.